here in Savannah this time to order. For purposes of the court reporter this morning, I would like all the commissioners and Mr. Amati to identify yourselves so that she can correctly reflect who it is making what comment. So we'll just start on the end down there.
Stan Wise.
Daryl Hicks. Rick Thompson.
Jamie Granville.
David Amati.
David Porter.
Okay. We're going to go ahead and move into the agenda. It looks like we have 14 different parts of the agenda today. Has everyone had an opportunity to review the agenda?
Yes.
All right. Are there any changes that need to be made to the agenda today before we recognize the order that we're going to take? Go ahead.
Just a couple, Mr. Chairman. In Section 3, preliminary hearings, item B, the matter of Carl Gilliard, we're continuing that pursuant to legislative leave. In item 4, under consent orders, we have two changes. Item G is being continued to the prelim calendar for the next commission meeting. And if you'll notice, we have a typographical error. We have two items listed as C. So the second C, which is after E, Ryan Williams, we're moving that to Q at the end of the consent calendar. That moved from the prelims to the consent orders, and we had a letter mix up. Other than that, the agenda should stay the same, and we should be good to go.
With regard to that, I guess the E, I'm sorry, the Q, the second C that becomes the Q?
Right.
I see that Mr. Knittel, he'll be in the middle of that. He'll have to stand up, another time.
Right.
Can we just go ahead and take those in order?
That's fine.
Okay.
Yeah.
We'll just identify it as Q, but we're going to go ahead and get all of yours, while you're up there just one time.
Thank you.
Are there any further comments with respect to the agenda?
Not to the agenda. The only other thing, Mr. Chairman, I'd say is because of the mic situation, if any of the commissioners intend to speak, maybe raise the hand and then make sure you turn your mic green so that the sound gets picked up.
All right. Thank you, Mr. Amati. With that being said, I'm going to go ahead and move to adopt the agenda. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? All right. So we're going to go ahead and move down the agenda to item number 2. We have to review and approve the meeting minutes from the last meeting, which was on September the 14th of 2023. Has everyone had the opportunity to review those minutes? All right, I'm assuming that's the case then. Is there any discussion that would be required with regard to the amendment? To the minutes. All right, hearing none, I'll go ahead and call a question again. In terms of adopting the minutes from the last meeting, I'll move to adopt those. Any second?
Second.
I got a motion and a second. Any discussion? Hearing none. We'll go, sorry, y'all. Hearing none, we'll go ahead and proceed with adopting the minutes. All in favor say aye.
Aye.
Any opposed? All right, that carries. The minutes from the last meeting are adopted. Next item on the agenda are the preliminary hearings. Again, it's my understanding that 3B is not going to go forward today. So we're just going to have 3A. And looks like Mr. Knittel, that's you, right? And again, just for the record, this is case number 23-0041-C in the matter of Davita Huntley.
Good morning. So in this matter, this will be a brief PowerPoint presentation on this particular case. Oh. Yep. In this matter, Ms. Huntley was a candidate for Atlanta Board of Education District 2 in the 2019 special election cycle. She filed the appropriate paperwork and was subject to filing requirements under the Campaign Finance Act. She lost the special election runoff on October 15th, 2019. Her last campaign contribution disclosure report was filed on October 11th, 2019. She ended her campaign with approximately $6,136.45 net cash on hand. Procedurally, this complaint was filed on September 21st of this year, and there are three allegations, all essentially the same allegation, just pertaining to three different filings. That she failed to file her December 31st, 2020 supplemental campaign contribution disclosure report. She failed to file the following year, December 31st, 2021. And again, December 31st, 2022, she also failed to file that supplemental campaign contribution disclosure report. We did, through UPS delivery confirmation, a notice of the complaint was on September 22nd of this year, and notice of preliminary hearing was also sent October 23rd with confirmation by UPS on that. There's been no response to this complaint. As the commission knows, under 21-534, committees or candidates which accept contributions are subject to the act. In this particular case, there's subsection G of Code Section 21-530 that she would need to continue to file a campaign contribution disclosure reports in compliance with the schedule. And in particular, she would be required to file a supplemental campaign contribution report no later than December 31st of each year until all of her contributions are expended. And so that's the issue in this particular case. Those are the three violations of 21-534. This particular page, I'm just showing the commission that it does show her last report was filed, was her October report. There have been no further filings, no additional ones. And this is just showing how it's alleged that she had additional cash on hand, net balance on hand. This is the page 1 of her September 2019 CCDR. And on this one, this is a summary page of her CCDR from September. The correct, she had some incorrect math on there, essentially, based upon her itemization in her report. So the correct net balance on this summary sheet for September, it should be $4,377.22 as far as the net balance on hand. And that just shows how those numbers came about. Listed all of her itemized expenditures, which she self-reported, and simply just her math was incorrect on that. This is the last report she filed in October 2019. Again, the summary page. The correct net balance should be the $6,136.45. And again, this comes from her self-reported itemized expenditures. She had reported itemized expenditures of a little over $3,000. The correct amount was this $25.46.77. So the corrections for all of her CCDRs ends up with her having a net cash balance of $6,136.45. And again, she's not filed any more CCDRs since that October filing, and therefore there's unspent campaign contributions, and she's essentially she just failed to file those, so there's reasonable grounds to believe that she has violated the act in those three manners, and that's what we're asking for the commission to find.
I've got one question on this, because I note that in the packet, with respect to this, this matter, it says it's in the matter of Davita Huntley and the committee to elect Davita Huntley. Which way are we, well, tell us why it's set up that way, and tell us how, if we have to make a motion with regard to both of those entities. In other words, do we have to say Davita Huntley and the committee to elect her?
Actually, yes, it should be with both of those entities. That is how she filed all of her paperwork, with both of those names.
So that's what would have been provided on the agenda? It should have been Davita Huntley?
Yes, and that's my error.
Thompson?
Did she file a committee registration? Is that what you're saying?
Yes.
She did file one?
Yes.
And if this does go to an APA, will this wonderful PowerPoint go with it?
I'm not certain, but hopefully the AG's office can use this to help them prepare.
Just to be clear, the allegations here are the failure to file a CCDR in the 3 years that reflect from December 31st, 2020 through December 31st, 2020. Oh, sorry, there's no 2022 there. Well, on the summary, it's only got 3. So it's 2020, 2021, and 2022.
Yes, that's a typo. It should be 2020, 2021, and
Oh.
2022.
Okay,
won't have a December
that's right.
Hasn't occurred yet, I'm sorry.
All right, I'm up to speed now, so,
Skipping Christmas there, Mr. Chairman.
yeah, that's right. Is there any other questions or comments for Mr. Knittel on this one? Hearing none, I'll go ahead and make a motion. I make a motion that we find reasonable grounds that exist that Davita Huntley and the committee to elect Davita Huntley failed to file the supplement CCDRs on 12/31/20, 12/31/22, and 12/31, I just got that wrong again. It's, let me just restate it. The dates are 12/31/20, 12/31/21, and 12/31/22, all in violation of OCGA 21-5-34I2. I think I've got that correct now. Any discussion? Or do I have a second?
Second.
Got a motion and a second. Any discussion? Hearing none, I'll go ahead and call the question. All in favor say aye. Aye. Any opposed? All right. So that one will go to OSA.
Yes, sir.
It looks like since that's the only preliminary hearing, thank you very much, Mr. Knittel, first of all. Since that's the only preliminary hearing, we're going to go ahead and move to item 4 on the agenda. We'll hear the line of consent orders that we have, and it looks like Mr. Cusack is going to begin on that. And again, I'll remind everyone that we're just going to have one presentation of all of the consent orders. If the commissioners have any problems or questions with regard to any of the one consent orders in particular, we'll go ahead and open that up, and then we apply the Hicks rule whereby we vote on these matters all together. So, Mr. Cusack, you want to go forward with that?
Yes.
Make sure that you call the agenda item, so it'll be 4A, and then that you call also the case number.
Yes, and this one's going to be 4A, case 2015-0069 and 2015-0070 in the matter of William Chip Rogers. And Mr. Rogers' counsel, Mr. Chalmers, is here via Zoom. So I don't know if we want to go ahead and unmute him.
That's not Mr. Chalmers.
Good morning, Mr. Chairman.
Mr. Chalmers, how you doing?
I'm doing well, sir. Hope you are.
Yes, sir, I am.
All right.
We're
And
going to go ahead and have Mr. Cusack's presentation. We'll let you say anything when he's included with respect to this case.
all right, this, just to rehash this, it's 2015-0069 and 2015-0070 in the matter of William Chip Rogers. Mr. Rogers is a former Republican state senator and state house member. This case came about, it was a third-party complaint, or 2 third-party complaints filed with the commission. The commission actually found probable cause. There was a preliminary hearing held in 2021, and the commission found probable cause on various violations. Mr. Chalmers and I have gone back and forth on this case before it reached the small stays, or the statements of matter asserted for OSA, which initiates the case. We're able to come to this resolution. Mr. Rogers is going to pay a $20,000 civil penalty for failing to file or failing to timely file campaign contribution disclosure reports, and then for failing to accurately report the total amount of personal loans to the campaign. So Mr. Rogers will be paying that civil penalty, and then the rest of the money in the campaign accounts will be being donated to charity.
What will happen?
The rest of the leftover funds will be donated to charity, or a 501c3.
Is the penalty being paid out of the campaign funds?
Yes.
Any other questions or comments for Mr. Cusack with respect to this particular consent order? Mr. Chalmers, do you have anything that you would like to say with regard to this case?
No, sir. It's been a pleasure to work with Mr. Kuzak on it.
Okay, I think that may be the first time that your comments have ever been that short.
Nope.
At least I'm glad that we got a laugh out of you for that.
Yeah. I'm not being paid by the hour on this one, so I gotta go fast.
Mr. Chalmers saying don't get used to that.
Okay, all right. Are you going to be signing off, or are you going to stick around for the remainder of the meeting?
I will stick around for most of it, sir.
Okay, all right, sounds good. Go ahead and move to the next one.
All right, and in the next one, it's case 22-0094 in the matter of William Park Freeman. Mr. Freeman was a candidate for the General Assembly in 2020 and 2022, and he failed to file 6 campaign contribution disclosure reports. He raised approximately about $1,500, and most of this was his own money. So he has agreed to pay the $625 in late fees for his failure to file. He was extremely cooperative, and upon receiving the notice of hearing in this case, got his reports filed, called in right away, and we were able to get this consent order across the finish line.
Just so you know, going forward on these, just also state for the record whether you have a signed consent order at this point. Okay?
Okay.
All right. With respect to the second case, are there any questions or comments for Mr. Cusack? All right, hearing none, let's go to the next one.
All right, the next one is 2016, it's actually agenda item C, but case 2016-0022 and 2017-0200, and that's in the matter of Osborne Nesbitt Sr. There's a signed consent order in your packet on this. This was two third-party complaints that came into the commission. Respondent in this case, Mr. Nesbitt, is the Rockdale County Board of Commission Chair. The violations he had, or in your consent order, were for accepting campaign contributions prior to filing a declaration of intent to run for office and failing to list contributions to his campaign in excess of $100, and that he failed to itemize certain PAC contributions to his campaign. Mr. Nesbitt has agreed to a $2,000 civil penalty for those violations and has amended his disclosure reports to properly reflect the violations in here.
Do the other commissioners, do you guys have that signed consent order in your packet? You do? All right. Well,
Yeah,
that's good. I don't know if everyone else does or not, but.
Is there any consent order you're presenting that is not signed?
No, that's why I was a little
That's what
confused
I
because
wondered.
everything,
That's why I was saying I wanted him to comment on whether he has a signed.
yes,
consent.
all of mine have been signed by the
All the
respondent.
consent orders are just all yours?
All of them,
Okay.
yes. Globally, all the consent
Well,
orders.
that takes care of that then, so.
Okay,
maybe
yeah, I
we
was a little
don't need to-
confused there. I was-
Okay.
The next one is agenda item D. It is case number 2018-0051 in the matter of concerned citizens of Richmond County. This was a little bit of a strange case in that it was a third-party complaint for an unregistered ballot committee for a local ballot question in Augusta on the James Brown Arena. So there was a question on the Republican and Democrat primary ballots for whether they would support a new arena in a new area of Augusta where the James Brown Arena would be moving to. Just as an aside, there was a referendum on that this year that passed, but this one was in 2018 and it actually failed. We had to send some subpoenas to figure out actually who was behind this ballot committee and sent them to the sign company. And what came back was that James McKinnon, who owns it's Cardinale Management Company, which owned the land where this arena was going to be, had paid for billboard space. And part of the email chain, the former mayor, Hardy Davis Jr., was on the email chain approving what went on this billboard that was purchased that said, vote for the new James Brown Arena. So it was actually two billboards that said they were paid for by the concerned citizens of Richmond County. That group never registered with the local filing officer in Augusta, Richmond County. And then we were able to receive this check, which was paid for, the billboards were paid for by Mr. McKinnon, but then ultimately the email exchange of Mr. Davis and Mr. McKinnon going back and forth of what was going to be on that billboard. So Mr. McKinnon was the financier of this group. He has evaded service of the commission. He is a New York resident. He has not responded whenever we have tried to call his office. We get through to his secretary, and he won't return our calls. We have mailed him the complaint, but he has just completely ignored us at this point. Mr. Davis was obviously, as the mayor of Augusta, was a Georgia resident, so we were able to serve him with this complaint. But for Mr. Davis's involvement in this, he is going to pay a $250 civil penalty for his involvement in this. And in a proportional aspect here, that's proportional to his involvement in this, where Mr. McKinnon actually was the money behind what this billboard.
Again, any comments or questions for Mr. Cusack with regard to this case?
I do. I think you've answered it. We're just resolving Mr. Davis as a party.
Correct.
And you'll have to decide what further actions on Mr. McKinnon that you can take. And then I assume the concerned citizens is not a legal entity that exists so that we can go, I mean, it would say,
Correct. It was
it's
never
a trade name, I assume.
trade name that was
So
just.
there's no there that we know of.
Exactly.
But those two parties still are out there.
Correct.
So we're just
correct.
getting Mr. Davis taken care of.
Correct.
Okay, thanks.
Yes.
Any other questions or comments for Mr. Cusack on this one? All right. Is that the end of yours?
Yes, that
Okay.
should be it for me.
Mr. Knittel, I think you're next.
Yes, sir.
And we're also going to, I want you to hit the one that would have been out of order.
Yes,
So that,
I will.
again, you don't have to go up and down, but make sure that you identify, the cases for A, B, or C, and then the case number, okay?
Yes, thank you.
All right.
The first case that I have is 4E. It's case 22-0110-C in the matter of Bathsheba Rem. And I believe this has Mr. Kyle Pask on Zoom. Okay. That's her attorney.
Mr. Pask, are you there? Can you hear us? Okay.
Yes, I can hear you. Thank you.
All right. We appreciate you coming, and we'll give you the opportunity to make any comments or ask any questions with regard to this case as well. But Mr. Knittel, go ahead and proceed with
Yes.
the background of the consent order.
So Ms. Rem was a candidate for Atlanta Public School Board of Education District 2 in the 2021 election cycle. She was unsuccessful in the general election in November of 2021. She had ultimately 3 CCDR violations. She failed to timely file election year June 30th, 2021 and September 30th, 2021, and then failed to file December 31st, 2021 CCDR. She also failed to disclose $1,100 in campaign contributions from one particular contributor, and failed to disclose $10,353.85 in expenditures on her October 25th, 2021 CCDR. There was an improper usage of just under $3,000, so $2,999.94 in campaign contributions for purposes other than to defray ordinary and necessary expenses of the campaign. In this particular case, bank records were reviewed, and I've spoken to Mr. Paskey on several occasions and worked with them to, these CCRs are now up to date and correct. So the consent that was worked out is she'll be paying a civil penalty of $4,625 plus 3 late fees, $125 each, for a total penalty of $5,000. And again, this is a case that I think Mr. Paskey began working with a prior staff attorney on this, but we have this now resolved. He's been very cooperative in reaching out to his client and getting these things corrected.
And I appreciate the cooperation, that was reached with regard to this particular case. And I did note, and I just want to have this covered, because I know that we've done this in the past, and maybe this will prompt more cooperation, with the office. But this is one that I've got a record of that was actually on the preliminary hearing calendar for our last meeting in September. Is that right?
That is correct.
All right, and the reason, as I recall, that we moved at that point was to give you more of an opportunity to work, toward a solution to this.
Yes, that is
Okay.
correct.
And again, I just think that that's a good example of, what we can do on this with respect to, with cases that are on the preliminary hearing, and if we can give some time to get it resolved. So, Mr. Paskey, do you have any questions or comments with regard to the consent order?
No, I mean, I'm happy to answer any questions the committee has, and to your last point, Commissioner, I was physically present at the last meeting. I believe it was in Athens, and I appreciate the committee's willingness to give us extra time at that preliminary hearing calendar, and I'm glad we were able to reach a resolution that hopefully the committee will approve.
Well, thank you very much. Are there any questions or comments for Mr. Paskey? All right, well, we appreciate your attendance. We appreciate the cooperation that, was given with respect to this case and reaching this solution. Are you going to stick around like Mr. Chalmers, or are you going to go ahead and be on your way?
Well, I do intend to wait until there is a vote taken, but then I do plan it with your permission to go ahead and sign off.
Oh, sure. That was actually a really good point about having to vote on this under the Hicks rule. Mr. Knittel, go ahead.
Thank you. The next consent I have is 4Q, which is 22-0161-C in the matter of Ryan Williams. In that consent, Mr. Williams was a candidate for Judge of Superior Court, Douglas Judicial Circuit, the Adams seat, in the 2022 election cycle. He filed a DOI on March 31st, 2022, and at the end of April of 2022, he withdrew from that race to then pursue a race for Chief Magistrate Judge in Douglas County, and he was subsequently disqualified from the Chief Magistrate Judge race by the Georgia Supreme Court. Had to deal with qualification issues. Not part of the consent, just part of the factual history of how this came about. His violations amounted to 3 election year CCDRs, failed to file September 30th, October 25th, and December 31st for 2022. He also unlawfully accepted campaign contributions prior to filing his DOI on March 31st. He accepted approximately $5,000 in campaign contributions prior to his DOI. Most of his campaign, he self-funded through loans to his own campaign, however. The consent, he has since filed all the appropriate paperwork and is up to date on that. The consent that was agreed upon was a civil penalty of $875 plus a late fee of $125 for a total of $1,000. And once we were able to get in contact with him, he was cooperative. It just took several times to be able to reach him.
Okay. Any questions or comments with respect to that case? All right, go ahead and move forward.
And the last one I have is 4F. That's case 23-0009-C in the matter of Miriam Ahmad. In that case, Ms. Ahmad was a candidate for DeKalb County Board of Commissioners, Super District 6 in the 2020 election cycle. She advanced to the primary runoff in August of 2020, and she lost that runoff. Her violations amounted to, she failed to file a December 31st, 2020 CCDR. She has since corrected that and completed it. She was very cooperative once she received notice of the complaint and immediately got on to take care of this matter. The consent in this case that we're presenting to the board, commission, is a civil penalty of $125 plus a $125 late fee, total of $250. And these are all signed, by the way.
we have any questions or comments with respect to that case? All right. Mr. Knittel, thank you very much for your work on those. I think next is Mr. Baywell. Again, identify the numbers on the agenda as well as the case numbers.
Yes, sir. My first case, position 4H, Devin Ward, case number 23-0036. Mr. Ward was the unsuccessful candidate for Atlanta City Council back in 2021. He agreed that he had 4 CCDR violations of 21-534 C2A. He also agreed he had 67 violations of 21-534 B1B. Essentially, he failed to list and itemize 67 expenditures on the appropriate CCDRs that exceeded $100. He also agreed that he had 8 violations of 21-533A. These were 8 expenditures that he agreed were not ordinary and necessary to his campaign. He's agreed to pay $500 in late fees, $5,500 in civil penalty, total penalty of $6,000. The next case I have, position I, Shalina Cook-Jones. She's the current Chatham County District Attorney. She was the successful candidate in the 2020 election cycle. She agreed that she had 8 CCDR violations of OCGA 21-534 C2A and C1B. She also agreed that she had 3 PFDS violations of 21-550 A1. She's agreed to pay late fees in the amount of $1,375. She's agreed to pay a civil penalty in the amount of $1,625 for a total penalty of $3,000.
With respect to that one, over what period of time were those violations?
The first violation was the last election year, 2020 CCDR, spanning through present. So it was one election year, and the rest were non-election year CCDRs.
Are there any questions or comments from Mr. Baywell with respect to that case? Or the one prior?
A quick one.
Sure.
In the consent order, it says she has taken active steps to be in compliance.
So,
What does that mean?
well,
I
she.
mean, are we filed or not?
They're not filed presently. She was filing under the old system, and she never registered for the new system. So she has already registered for the new system, and now I've been working with one of her assistants and her also, and she's in the process of getting basically 4 years of bank statements uploaded onto our system. And I will just add, too, this is also a relatively recent case. I think we probably got the bank statements around November of this year. So this is not a case where, you know, she's just been sitting, not getting stuff done. There's actually been a lot of work to respond to us and to also register and start getting this stuff uploaded.
All right, thank you.
Yes, sir.
Vice Chair Thompson?
Why are we bringing consent orders up if they haven't fully complied? What's going to be, why would she go ahead and file the rest of it if we approve a consent order? I mean, shouldn't we wait until everything that needs to be done, all actions are taken, are completed before we present these?
That would be up to the board. The only other thing I can also say is she's going to have another CCDR due December 31st. And with the way the system works, she understands that she's going to have to get all her prior transactions uploaded onto our system before she can file prior CCDRs, and she's going to need that to file the December 31st CCDR of this year.
And again, I'm sorry.
No, go ahead.
Just for clarity purposes, though, if additional violations occur, what we're doing today does not keep you from filing another complaint against her, right?
Correct.
Yeah, I don't know. My personal opinion is we shouldn't bring resolutions up for a case that actually haven't been resolved.
Understood.
That's just my opinion. I'm only 1 of 5. I can count.
Are there any other questions, comments with respect to that case? All right, Mr. Baywell.
I do have a
Oh,
question.
sure.
The point he's bringing up is valid. the point he's bringing up is valid. I mean, shouldn't we just continue this case until it is resolved?
Well, I think that we're to the point where there's already been a consent order signed.
But we haven't adopted it.
Well, I understand, but again, if we're not precluded from bringing new charges, beyond what's covered here,
So the question is, my assumption is based on how she's working with staff, that she'll probably do this, but what if she does not do it? Then can you bring something back before this body that this body has already approved?
So the answer to your question, Commissioner Hicks, is no. But I would say there's a little nuance to Commissioner Thompson's question. There is. We've reviewed the bank statements, so we know the activity that's occurred. So we've said this is the appropriate penalty for not filing these reports. Whether she files them tomorrow or in a month, that's not changing the analysis of what the appropriate sanction is. If we didn't have bank statements, if there was uncertainty about whether there were additional violations, how she used the money, if it was inappropriate, then I would agree with Commissioner Thompson that we need to wait and see. But in terms of, we know what the violations are, we know that there are going to be no additional violations over this period, we know what the appropriate sanction is, in my personal opinion, again, I think we're okay to move forward.
I don't know how we want to do this, under the Hicks rule.
I've already marked it, we're going to bring it out separate.
Thank you.
So I think you probably, in the vote, you're going to bring it out separate.
Correct.
Okay, all right.
All right, so that was item 4I, is that right?
Yes, sir.
Okay, go ahead and proceed with your next one.
Position 4J, Robert Dawson, case 23-0043. Mr. Dawson was the unsuccessful candidate for South Fulton City Council in the 2021 election cycle. He agreed that he had, excuse me, I misspoke. That's correct. He was the unsuccessful candidate for South Fulton City Council in 2021. He then went on and ran for Georgia House of Representatives in the 2022 election cycle. He was the unsuccessful candidate for that run as well. All these violations encompass both of those candidacies that he had. He agreed that he had 7 violations of OCGA 21-534 C2A, failing to file CCDRs on the appropriate timeline. He also agreed that he had 1 violation of 21-550 A1, a PFDS violation. He agreed to pay $1,000 in late fees, $500 in civil penalty, for a total penalty of $1,500. Position K, Dexter Sharper, this is case 23.
Let me just make clear, does anyone have any comments or questions on that case?
I guess I would like to make sure that when we're presenting the consent orders, that you guys advise us whether everything has been filed, right? Just
Yes,
going
sir.
forward, please, so we know.
Okay, Mr. Dawson he does have everything filed for both positions, South Fulton and on our site for the Georgia State House of Representatives. Position K, Mr. Dexter Sharper, this is case 23-0032. Mr. Sharper is currently on the Georgia State House of Representatives. He agreed that he had 6 violations of OCGA 21-534 B1A. He had 6 contributions of over $100 that he failed to report and itemize on the appropriate CCDRs. He agreed that he had 2 violations of OCGA 21-534 B1B. He had 2 expenditures of over $100 that he didn't report on the appropriate CCDRs. He also agreed to 3 violations of our rules and regulations. The Rule 189-3-.04. This rule covers situations when a candidate personally pays for campaign expenditures and then reimburses themselves. They're allowed to do that, but when they do that, they have to identify the end recipient who's receiving the money. So his violation was just not identifying the end recipient. He agreed to pay a $1,000 civil penalty. I will say on Mr. Sharper, this is a case where the filing errors were on our old system, and he's also filing on our new system. His filings are up to date. But we did not go back in and open up the old system, but we did look at his bank records, and we did verify that those were violations that occurred. But because it was on the old system, we didn't reopen it, and he didn't go back in and correct them.
Commissioner Thompson?
If he hasn't corrected it, how is his total accurate? Okay, because it had to roll forward. My first question is, you talked about the contributions and the expenditures that they weren't reported at all, or they just weren't itemized? Were they on the summary page under 100, or they weren't reported at all?
They weren't reported and they weren't
Then
itemized.
how does he have a accurate cash on hand right now unless the staff manipulated or changed, manipulate is probably the wrong word, but it might be the right word, I don't know. Changed the total. How's his cash on hand right?
The new system does have a carryover balance that starts. So essentially, they do start on the right track and not,
How do you, so it's my understanding when we started the new system, the staff went in and carried the numbers forward from the old system, okay? If that is true, then this was not taken care of before we started using the new system. So the number that was carried forward from the old system is wrong. So how is his bank total statement accurate now?
you can manually input the amount too on the carryover
And
balance.
who did that?
I'm not 100% sure, and not to put Mr. Cusack on the spot, but I know he also.
The Deputy General Counsel is coming to the rescue here.
I know Mr. Cusack also worked with Mr. Sharper on this a little bit.
Yes, and you're right. And so we would put in a
What'd
commission.
you say?
You were right. We would put in a commission-generated transaction. So because going back on the old system is going to throw off everything on the new system, then we can just,
Just tell me what you guys did.
yes, so on the new system, there would be a contribution saying, input by the commission to balance the account, to bring the numbers correctly. So that's what we did. So the numbers are correct on the new system, and it's just generated by us.
When did you do that? Did you do it on the very first report that's in the new system? Did you start at a different report? So are there some reports that are wrong and you just changed like when you found this out? I mean, I just don't know if somebody's looking at the whole picture on here, how they know what is accurate and what's not.
So this would have been on the most recent report. So we would go back and amend the most recent report of
To
his.
change the number.
Yes.
Is there going to be, on the addendum statement, is there going to be an explanation why the number changed?
Yes, so that goes in there. On the addendum statement, it says the commission has generated this to rectify the balance, but then also on how it's reported on the contributions, it says it's entered by the commission. Commission-initiated contribution to balance report. So that's how it's entered. And you may see that on a couple filings, but that's sort of the best way we get the balances in check.
Thank you, Mr. Cusack. Mr. Baywell, well, are there any other questions or concerns with regard to that consent order at this point? All right, Mr. Baywell, go ahead to the next one.
Yes, sir. Position 11, Davis Pool, case 22-0153. He's currently on the McIntosh County Board of Commissioners. He was successful in the 2022 election cycle. He agreed that he had one violation of 21.530.2C. This is the prohibition of campaign contributions by public agencies. What happened in this case, Mr. Poole was running for county commissioner. He received a ride from the sitting sheriff in a vehicle that was purchased by the McIntosh County Sheriff's Office. There was also an arrangement that the sheriff made to use a county barn or county facility, as it was described. And there was a meeting that the county sheriff took Mr. Poole to. Mr. Poole talked to, was approximately 8 to 10 people about campaigning. So that was the violation of 21.530.2C, using the sheriff-owned vehicle for the ride and speaking to the 8 to 10 people at the county-owned, it was a maintenance facility. He also agreed to one violation of 21.550A 3.1. This was a PFDS violation, and he agreed to one violation of 21.534B1. This was a filing error where he failed to report $5,827.91 in campaign expenditures. He has fixed his filings. He's agreed to pay a $125 late fee, $1,500 civil penalty, total penalty of $1,625.
Any questions?
So he is not the sheriff, is that true?
Correct.
Okay. Was this a staff-initiated complaint or a third party?
No, sir, it was a third-party complaint.
So if I'm not mistaken, under the statute, it's both a violation for him to accept it.
Yes,
but
sir.
It's a violation for the sheriff to give it.
Yes, sir?
So is that the next case?
Yes, sir?
Well said.
Any other
I
questions?
do
Sure.
have one question.
Yes,
Now,
sir.
If it chooses, I'm not speaking for McIntosh County, they can take whatever action they feel appropriate for use of their property. That's not our issue. We're only concerned about the campaign finance. You know, this is a contribution in kind that we need to address. If McIntosh County chooses to, and I have no idea, they can take whatever action they feel appropriate for private events on public property. But that's their call.
Correct,
Okay.
correct,
And we have nothing to do with that.
correct. Position M,
Well, hold on one second. I just want to make sure there are no other questions with
Yes,
regard
sir.
to that case. I thought Commissioner Hicks had something. I'm sorry. Okay. Oh, you did? Oh, okay, sorry. Okay, go to the next one.
Position M, this is Stephen Jessup, case 22-0152. Mr. Jessup is currently the McIntosh County Sheriff. This was a companion complaint that we received with the prior case, Mr. Davis Poole. Mr. Jessup's role in this, again, he was the sitting county sheriff. He had access to a vehicle that was purchased by the sheriff's department. He took Mr. Poole to this event at the county-owned maintenance barn, and Mr. Poole spoke to approximately 8 to 10 people about his candidacy. He agreed to one violation of OCGA 21.530.2B, and this was because, as an agent, he facilitated the use of public agency property for a campaign contribution. He agreed to pay a civil penalty of $500. Position N.
Any
debt-
questions or concerns with regard to that consent order? All right, go ahead.
Position N, Devin Dabney, case 23-0053. Ms. Dabney was the unsuccessful candidate for Johns Creek City Council, post 2 in the 2023 election cycle. This was a third-party complaint that we received. She agreed that she had one violation. She failed to file her October 25th, 2023 CCDR. She has fixed that filing error. She's agreed to pay $125 late fee, $125 civil penalty, total penalty of $250.
Any questions or comments for Mr. Baywall with regard to that case? All right, I think you have one more.
Yes, sir. Position O, Angel Gaines Dingle. This is case number 23-0039. Ms. Gaines Dingle was the unsuccessful candidate for South Fulton City Council in the 2023 election cycle. This was a third-party complaint. She agreed that she had two CCDR violations of 21.534 C2A. She has fixed the filing errors. She's agreed to pay $250 in late fees, $125 in civil penalty, total penalty of $375.
Any questions or comments with regard to from the commissioners with regard to that case? Okay, thank you, Mr. Baywall. I
Thank
think
you,
we've
sir.
got one of these for Mr. McCarter.
So I've got item 4P. This is civil case number 23-0045-C in the matter of Rob Jones.
Hey, move the microphones closer to you. I don't know if the court.
Can you hear?
Yeah,
Got it, okay. So Rob Jones served as the county commission chairman of Pickens County for 16 years from 2004 until his unsuccessful reelection effort in 2020. After an audit of Pickens County, the complaint was initiated by me on October 16th, 2023. It was found that Mr. Jones failed to file reports for September, October, and December of the election year 2020, as mandated by law OCGA 21-5-34C. Upon receiving the complaint filed against Mr. Jones through his attorney, Philip Landrum of Pickens County, contacted me to provide an explanation on why these reports were missed. And he also provided all the bank statements and everything that I requested through a subpoena. So it was 2020. It was a difficult year for everybody with the COVID-19 pandemic. And Mr. Jones had the added hardship of losing his spouse, who took care of meeting all the financial requirements. And Mr. Landrum acknowledged that that's not an excuse. He was very cooperative, and they acknowledged that he had missed those filing requirements, and we came to a consent order. I believe the penalty was $300 in late fees. Overall, it was a pleasure working with Mr. Jones and Mr. Landrum. Really great case to have my first consent order for the commission.
All right. I believe that Vice Chair Thompson has a question.
Is this your first time in a mosh pit?
Yes.
Okay. So my first question is this. Is it $300 or was it $375? Because you said it was $300, but the consent order says
Whatever the consent
$375.
order says is correct. It's $375.
My other question is this. So of the 3 reports, were there any contributions or expenditures that were not reported on those reports? Or were they just zeros?
I believe they were just zeros. Yes.
Okay. I was trying to find more things.
Great. Perfect.
Any other questions,
And it
comments
is
for
signed
Mr.
as well.
McCarter?
The Dormant Commerce Club?
Oh, my God.
question that you want to address?
Go ahead.
I'll defer to the Supreme Court on that one, though.
All right, any other questions, comments? All right, thank you very much, Mr. McCarter.
Thank you.
I'm going to go ahead and make a motion that we approve all of the consent orders 4 through Q on the agenda, with the exception of 4I, which is in the matter of Shalina Cook Jones. Do I have a second?
Second.
I got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor say aye. Aye. Any opposed? Okay, all those consent orders with the exception of the one are therefore approved. Now, we're going to go ahead and reopen discussion with regard to 23-0038C, which is in the matter of Shalina Cook Jones. And I've got the first question. I know, Mr. Amati, that you already answered Commissioner Hicks' question, but it was simply with a no. I want to know that if we approve this consent order today, what exactly does that preclude the commission from doing in the future?
If the commission approves the consent order in the case of Shalina Cook Jones, it would preclude the commission from adding any additional violations covering the time period that the consent order alleges. That being said, there are no additional allegations that would exist to add because we've reviewed all the bank records. If there are additional violations moving forward, starting in the December 31st CCDR moving forward, or any PFDS issues, we would be available to avail ourselves of the ability to file additional violations.
It would be a whole new case.
It would
at
be
that
a
point.
completely separate case.
Okay. Vice Chair?
I understand that, when we rule on a case, that it's based on the specifics. However, I do think it creates a bad precedent for us to approve a consent order, especially if there's no language in there saying that they agree they will do it, okay? It just basically looks like it's done, unless I'm missing something.
What's the language in the consent order with regard to what Vice Chair was talking about?
Do you see my point? Kinda, not really?
I understand the argument.
Okay. Oh, yeah, you don't have to see my point, you just understand what I'm saying.
Yeah.
Okay.
The point I would make and I hear, the violation was the not filing. That's like speeding. That violation occurred, she's admitted to it, she's paying a fine for missing those dates. So, I mean, I'm not belittling the need to get it right, but she's admitting she didn't file on those appropriate dates, she's paying a fine for that. And whether she files or not, I think is relevant, maybe relevant to the consent order, but the violation still occurred. I mean, we have a lot of orders where we don't ever get the correct filing because the people are gone. So I'm not saying we shouldn't hold up. I'm saying she's admitted, the violation occurred on those dates when the reports weren't filed. She's admitted to that. She's paying the fine. So, getting it right obviously is good and what we want, but she's still, the violations occurred, in the past.
I guess the only point I still want clarity on.
No, I
is-
understand.
Is if we sign this consent order, again, where's the line drawn at that point? I think that the commissioners are all, making valid points as to whether that needs to be, concluded at this point. But
The line, to your question, the line is drawn at June 30th, 2023. Any violation that occurs after that, we've never alleged anything, and therefore we have the right to file additional complaints. But we've covered everything up to June of 2023.
Remind me, is this person in office or?
Yes, they are currently in
They're
office.
currently in office, so they still have more reports to file.
Yes.
So I believe it's our duty to allow the public, especially since they're an incumbent, to see all the reports. And if she hasn't filed them, and I understand we're hoping she will or whatever, but I don't have to sign the consent order, so only the chairman does, so.
Well, again, my only point, go ahead.
From my perspective, I think you've answered my question. And my question pertained mostly to, is there a circumstance in which she would not be responsible for what she has consented to? And you said that she's responsible for what she's consented to, just like anybody else who has signed a consent order. I mean, what happens if anybody else who signed one doesn't pay? What do you do? Because now, from my perspective, it's only about the payment.
Right.
Has she paid? Or no, because we
We don't take the check until it's signed.
So, but once it's signed, not her, but anybody else.
Right.
What happens if they don't pay?
So this has occurred before.
Okay.
And what we would do is we'd reach out to the Attorney General's office, and I believe his name is Ryan? Zach Johnson. We have an attorney at the Attorney General's office who will file essentially a lien.
An order enforcing the judgment.
And so we've done that before, where we've gone to the county in which they reside, and the courts will then in that county garnish the wages at the, whatever applicable percentage of the wages over time to have that paid back.
All right, I think you've answered my concerns.
And typically, when we do that, we get paid.
Okay.
Again, just correct me if I'm wrong, because I really want to make sure that I
Sure.
understand this. For anything that occurred up to June 30th of 2023, anything that would have occurred prior to that date is covered, and there's nothing else there beyond what has been agreed to in the consent order.
Correct.
And for anything that occurs after June 20 of 2023, commission staff could at that point pursue the additional charges against her.
Correct.
Okay. Any other comments from the commissioners? All right, I'm going to go ahead and make the motion that we approve the consent order in case 23-0038-C in the matter of Shalina Cook Jones.
Second.
Do I have a second?
Second.
I got a motion and a second. Any discussion? All right, all those in favor say aye. Aye. Any opposed?
Aye.
All right, that approval will apply. And I just, again, want to make clear that for any additional violations, new charges, can be brought.
Correct.
All right. I believe that takes care of all the consent orders that are on the agenda. I'm going to move on to item 5 on the agenda, which are the administrative dismissals. again, there is no action to be taken by the commission with regard to the administrative dismissals, but if anyone has any comment or question about what is occurring with regard to these cases and why they're being removed, just feel free to talk about it. Go ahead.
No, I was just up here for the next agenda
I
item.
thought I was thinking there was going to be I'm sorry.
No.
It's really funny because when Jake was the chairman, that I was always the one that said, we don't do anything on those.
So we don't need, I mean, the commissioner's asking, do we still vote on it? I don't think you.
No, I know we don't do that.
No, you would need to take a vote to reopen an administratively dismissed case.
All right, Mr. Cusack, thanks for that item on the agenda. All right, now we're going to move to the OSA decisions. And the first thing I want you to do before you get into the OSA decisions is to explain where we are in the process at this point.
So commissioners, when we get a decision back from OSA, that means we've gone through the process of a preliminary hearing. The commission has found reasonable grounds to believe that a violation of the Campaign Finance Act has occurred. The 30 days has lapsed where after the probable cause or reasonable grounds has been found, we have the opportunity to work out a consent order. The consent order wasn't worked out, and then we have formally referred the case to the Attorney General's office. From there, the Attorney General files what's called a SMA. It's a Statements of Matter Asserted. It's essentially a charging document that starts the procedures or starts the process of the case in the Office of State Administrative Hearings. From there, the respondent can file a response. They can file motions for summary judgment, various evidentiary motions, file subpoenas. The discovery process is ongoing at that point. From that point, we get a notice of a hearing at the Office of State Administrative Hearings in front of an administrative law judge, and then the parties will then have that hearing. And that is what has happened in these cases. From after the hearing process has happened, the administrative law judge will make what's called an initial decision. It's a little different from a final decision, which is what most agencies have. We're a little different in that we get an initial decision. And the reason we get an initial decision is because you are one of the few commissions in the state that can actually go back and modify the initial decision from the administrative law judge. You can choose not to accept the decision from the administrative law judge, or if you're good with it, you want to adopt it, you actually just take no action. So it becomes by operation of law, it becomes the final decision if you don't take any action within 30 days of the initial decision being finalized or formalized or being transmitted to the parties. Now, say the respondent is unhappy with the initial decision, they could actually file a motion within that 30-day time period wanting to bring it back in front of you to try to modify it as well. So that's where we are in the process, where we are, I still believe, within that 30-day period right now. On these cases, we're going to ask you to take no action, but I'm going to give you an update on these cases. They've gone through the process, what was ultimately the outcome on the case, and why we are in support of what happened at the Office of State Administrative Hearings on these cases.
Does there have to be a vote to take no action?
No, there doesn't have to be a vote.
Okay.
So why are we bringing this up if the 30 days has not lapsed yet? I mean, because with the 30 days, the individual can file something, right?
Sure. So you're absolutely right. We could come back in March and say, well, they filed a motion. We need to, it has to have a hearing. What we're doing is we're updating you on it because at the last commission meeting, it was commented, we haven't really heard of any of these cases that go to OSA in a while. And so we felt like, hey, we've got some orders sent back to us. It's good to be timely and update you on those and explain why we're not making a motion to amend it during the window.
So this is just an update?
Yeah.
If we don't take any action, I mean, are we in the posture if we take no action, then it's just going to, after the 30 days, be applied?
Correct.
That is right.
So we are taking action by taking no action.
Right. Well,
So I don't understand the process here. If it's an update, yet we don't do anything about it, what if we want to do something about it? There's still 30 days for the individual, I mean, there's still time on the 30 days to do something.
So
If we wanted to reject it, we could do that now.
you
Yes.
could do that.
We could.
My point is, technically, and I'm not saying we ever would, but staff could just not update you on this at all, and it would become final. I think it's better that we talk about it.
I don't know that's true. It's my understanding that it has to be brought back before the commission. After OSA, it has to be brought back before the commission. Staff doesn't get to, hide the ball.
I don't think that's how the rule reads.
I've never seen a case come back to the commission after it's already been,
Yeah. We've had them before.
Well, but they usually come back as consent orders.
oh, yeah.
Yeah, we've had them before, but I don't know that there's ever been that OSA actually has done a judgment. That, this may be some of the first ones.
Well, I guess the problem is, what would we have to do? Call a special meeting? If someone wanted to, not approve?
No, I think they just have to file the motion within the window, and that stays, it tolls it being finalized until the next meeting. Mr. Cusack can correct me if I'm wrong, but I think that's the,
Yes, you can file the motion and then have the hearing later, as long as you're within that 30-day window,
But that's a decision of the staff.
or the other party, correct?
or the respondent.
Right. But I think what Vice Chair is saying is that, we're not going to really be able to take any action on that unless we call a special meeting to approve that. I mean, well, to object to it in the event that somebody
We
wants
can
to.
object to it now,
Yeah,
But the 30 days hasn't run.
but we can reject it right now.
Within the
If we
30.
think
Yes.
the ALJ got it wrong, we can say no.
but my bigger concern is your comment that, and I know you guys wouldn't do this because we have a great staff, but there's been times that, other people may do it. We need to figure out whether or not the staff has to bring it in front of us.
You're talking about a rule change to make sure that they all come back.
I think the rule actually says what it says. I'm not a lawyer, so I don't know, right?
And if you're right, but to your point, I don't disagree with the concept you're driving at, which is that after an OSA decision is made, it should be required to come back before the board. But the way I think Mr. Cusack would be looking at it, but my recollection is that there's it just says if no action is taken, it becomes final.
But we can't not take action if it doesn't come in front of us. That's my
That's
point.
right.
Correct.
No, I mean, he's right about that.
Yeah,
Is there any
you're right
way
about
to put an automatic stay or anything on the case until we have a next regular meeting so that we don't have to call a special meeting every time there's a decision from OSA?
Right.
But we're not required to take action within 30 days. Is that what you're saying?
No, what I'm saying is that it's already going to be approved because we don't take any action. If there's any way for us to take the action on it, again, what I'm hearing is that it is going to become permanent if the 30 days goes by, right?
Correct, and no action is taken.
Right.
Well, then that's wrong. I mean, we're gonna have to change that because there's no way that it's a rule.
It's a matter of law.
It's a rule. Because Donnie was part of that, making that rule up because
What about 16 years ago, maybe?
So that has never been my understanding. If that's exactly what you guys say the rule says legally, then we need to change that immediately because we're charged by the statute to both have the initial finding of facts or reasonable grounds and the hearing as well. Just because we shoved it off to OSA doesn't relieve us, I don't think, of having that last part of it.
So I'm looking at it now, Commissioner Thompson, and you're wrong, but so am I. But you're more wrong.
I've never been wrong.
The exact language of the rule is, the initial decision will become final by operational law unless the respondent or the Attorney General's office. So it's not even staff that would file a motion to amend, and I see Ms. Young smiling, it would be
Or
the
climbing
AG's
under the
office.
desk.
So why is this even an item on the agenda?
Yeah.
Are you just providing an update on the cases
No,
as
if
opposed
we
to?
want to reject it, we can do it right now. That's why it's here. If
No,
we-
that's what he just said. The Attorney General's office
Has
is
to
doing it.
make
We don't have the ability to do it based
Well,
on what he's reading.
Here's with the Attorney General's office making that, we are the client at that point, so that would be part of we'd be directing them to do so on our behalf.
You would. We wouldn't because
Oh,
we
yeah,
wouldn't have the
yes.
ability to.
Yeah, that's a dumb rule.
But you get the point I'm making.
I hear you. That's what it says.
If we don't bring it forward, you would never know until it's done, and I don't think that's good either.
It wouldn't matter anyway. You bring
I
it
know.
forward, even if we disagree, is my point. You know, it's up to the staff, or I guess we could direct the Attorney
You could direct the
General.
Attorney General.
This is dumb.
The commission is the commission, whether it's staff or the board, I mean,
Yeah.
but,
Again, the only way for us to, well, are you saying that we could direct the Attorney General to do that somewhere at some point of, rather than a, meeting here where we would actually vote on that?
I think Ms. Young's,
Ms. Young?
Hope it's okay for me to just pipe in. So this is actually kind of a fortuitous discussion because these two orders, the timing of them is really convenient. They came in right before a scheduled meeting. There is a statute that would supersede any rule that this commission has. It's OCGA 501341, and it sets out a procedure for these initial decisions. There's a 30-day window for either party, including the commission, to object or try to modify or overturn an order. That can be extended, and we have done that in the past. But you have to do that administratively within 30 days. You can only extend for up to 30 days, and then after that, you can extend again.
How do you extend?
I'm sorry?
How does it get extended? I mean,
We did, when we have done that before, we have just circulated a consent order. One-page written order saying we are extending this deadline to such and such, and you do have to explain why. It's usually because of administrative scheduling issues, to give the commission time to either figure out, do you need to set a special meeting, or do you need to, or can you address it at the next regularly scheduled meeting? Now, this is going to be an issue, not so much for these two cases, but we've got one more case that has been fully, we had a full hearing in front of an ALJ, and I expect her to enter an order any day now. So it could come in today, it could come in tomorrow, and we've got 3 months till our next regularly scheduled meeting. So I'm glad we're having this discussion, because I will want to make sure that I know what we need to do from our office to make sure that y'all are informed about the decision when it comes in. And if we want to do any extension orders, set any special meetings, that we can do that before we have any statutory time window close. With regard to these two today, I think the appropriate thing to do would be to look at these two opinions substantively, and then if anybody has any motions to make at that time in terms of whether you want to propose that you might want to, either take an action to either reset the case for a special setting, or if there's an objection to what the ALJ has ordered in either of those cases, this would be the time to figure out what to do about those two, because we are within that window that the deadline can be extended, or if the commission is perfectly happy with those orders and would like to take no action, you could either make a motion and formally vote on that, or just decide to do nothing.
Will you go back to what you said earlier about these extensions that
Yes.
can be provided by consent order? I assume that since you're calling it a consent order, that it has to be.
I'm sorry. That would have been a misstatement. The judge's order, the initial decision, there's a 30-day window for this commission to do anything that it wants to do. If there's something in the ALJ's initial decision that it is not happy with. If nothing is done within that 30-day time period, by operation of law, it's going to become a final order rather than an initial decision. Now,
Go ahead. You have to break it down for me.
Okay.
I don't understand. So you have 30 days. We have 30 days, or I guess we don't. The staff has 30 days to do something. But the defendant, or whatever we want to call them, they have 30 days. The respondent has 30 days too. So how could we do anything if they still have time left?
Well, typically, only one party is going to want to do something.
No, I understand that, but I'm just saying, how can we do anything if the respondent has time left
Well, if
too?
the respondent files a timely request for further review, then that would just be a matter of, I think, setting it on the next agenda for the next available meeting to have the commission do that review that they have requested.
I think the point of presenting these today is to give the commission the opportunity to say, we want the Attorney General's office to file a motion.
I understand what you're saying. I'm more, and this has nothing to do with these cases, okay? I'm more concerned of the procedure that we have. Again, the staff we have now, I have no concerns about. But we're setting precedent, and if this is the way the rule is now, then I think we have a real problem. And I understand what you're saying is that there's another law. But the other law you're referring to, correct me if I'm wrong, is because we're allowing OSA to hear the cases. If we weren't allowing OSA to hear the case, if we heard the case like the law says we should, okay, then after our decision, we would have, they would have 30 days, and then we wouldn't have to do anything. Am I making sense?
No, I understand what you're saying, but being as how we are at OSA, again, tell me if I'm misunderstanding this. Regardless if I call it a consent order or a regular order that's entered by the ALJ, if that goes in, then it can be extended long enough for the case to then get in front of us to say whether we, reject it or not.
Did we extend Oxendine 30 days?
We did.
So it's a written request by the AG's office does the ALJ sign it, or is it just a written request to extend it 30 days?
You don't need the ALJ to sign
So-
it. I believe I can't remember if we had all the commissioners sign it or if it was just the chair. I think it was just the chair. But everybody was notified and had the opportunity to participate in that decision. But that was to, we'll need to, any time that we have an OSA decision that comes in that, isn't within 30 days of a regularly scheduled meeting, we'll need to make sure that those dates are protected so that something doesn't become final by operation of law just because we've missed a deadline. The deadline can be extended, or if let's say there's 3 months until the next meeting, or we think it's too long, we could always do a special setting if needed.
So can the extension go so far as 90 days? If the order came down today?
There's a
could-
60-day limit under 41. You can do it for 30 days once, and then again for 30 days. And the statute speaks to having to proffer reasons for that extension that, explain why that time is needed. So any decision that comes in right after a scheduled meeting is going to be a little bit tricky timing-wise.
That's going to require a special meeting.
It may.
How often does that happen? You're talking about there may be a different situation if it
Not,
happens. in the first
not
30
very
days.
often. I mean, the last time it happened was in the Oxendine case, and that's been a couple of years now.
Well, I completely agree with Commissioner Thompson on this. While these cases are still within those 30 days, I can't see how we can do anything today other than get information from you. Is that right? I mean, there's no action for us to take today.
That's wrong. If we
I agree.
object to this
You
either
can direct
decision,
the AG's office
we
to-
can vote to reject them and take the case back.
I don't know,
Or
I don't know if it's a vote so much as directing staff / the AG's office to draft a motion to amend the order. But you can only do that if we present it here and give you the information about the initial decision.
But again, I don't see how we can do that when the time hasn't run for both sides to file that. I mean, again,
Well, so it-
circumstances could change in the next, up to the, 30, however many days you have, 15 days or whatever it is at this point. I think it's going to be speculative to just automatically assume that, at that point, we're going to be able to approve it, or that today, we can actually object to it. When that 30 days is still running.
But that 30 days running is the only time you can direct.
Once the
an
30
objection
days
to it.
runs, it's final by
So
operation of law.
you would need to direct the AG's office to file a motion to amend the order now, or we lose that right.
Is this by law or by our rule?
Well,
It's by law.
I think it's by both, but if there's a
50-13-41.
difference, then the law would
Right.
obviously supersede.
That's a dumb law.
May I think I understand where the confusion is. This commission's review is in no way dependent on whether or not any of these respondents appeal. If the respondents choose to appeal, that's up to them. But let's say they don't. The commission's only analysis is there something wrong with this order that the commission wants to appeal? And that's something that the commission should do without regard to whatever the respondent's going to want to do. But if the commission doesn't want these opinions to become final by operation of law, then an action needs to be taken before that time period expires. Whether that's an extension or a direction to file the appropriate motion that gets it back on track for further review.
Well, I asked Mr. Cusack at the very beginning whether this is going to require a vote then. Because he just said,
It doesn't necessarily require a vote, but there is an opportunity for a vote if the commission, if any of the members feel that that's needed.
And I might have phrased that poorly of if you want to reject it or modify it, then there's a vote. But if our suggestion as staff is going to be to accept these and to make no motion and let it become a final decision by operation of law, we're very happy with these orders. So that was going to be staff's position on these particular orders today, was that no action be taken so that it becomes a final decision by operation of law.
So does the respondent know that we're taking this up, yeah?
Well, in addition to that, we haven't been presented the decision, have we, in the materials?
We haven't even gotten to that yet.
Oh, okay.
Yeah, and they should be in the materials, the both decisions. Yes.
Okay, I didn't see him.
I meant he hasn't gotten.
He's
to-
gonna get into
Yeah,
it.
yeah.
All right, well, I guess proceed on.
Okay, and I'll just do a quick summary of what these cases entailed and sort of what happened. 2018-0100 is in the matter of Thomas Cheek. Mr. Cheek was a candidate for the Cobb County Board of Commissioners, and he failed to file 4 campaign contribution disclosure reports. Mr. Knittel actually handled and testified on this case. We, as staff, become the witnesses at the Office of State Administrative Hearings, and Ms. Young is the one questioning us, so we're the client in that setting. But OSA imposed a $26,000 civil penalty, which was the maximum amount that they could impose, and that's why we're happy with this, because it's setting the precedent of when these cases, when you fail to file and you take no remedial action, you are going to be hit with the maximum amount of penalties there. So that's why we're asking you to take no action and let it become final by operation of law, is because this is setting the precedent that when you do go to OSA and you don't comply with the Campaign Finance Act, these penalties are going to be heavy and significant. So it gives us, I don't want to say more negotiating power, but it underlines the severity of if you don't comply with the act, there are penalties down the line that could be very heavy. 20007-C is in the matter of T. Antoine Stevens. This was one where I took over and testified on. It's a kind of an interesting case, and we're seeing more and more of this. I'll get into a bit of the facts because I think you would find interest in this. But Mr. Stevens was a candidate for the Athens-Clarke County mayor race, and he, on his first campaign contribution disclosure report, he ended up not qualifying to run. But on his first disclosure report, which was before qualifying, he put that he received $100,000 in small dollar donations on his report. And it created all sorts of sort of news because it was like, this is a local mayor's race. This guy is saying he raised $100,000 from small dollar donors that don't have to be put on a disclosure report because of the amount. So you're talking a lot of people would have had to donate to his campaign. And it generated a lot of buzz in Athens because of this, because nobody had ever seen that amount of money. And the news media there started digging in, started trying to get quotes from him, and it finally came out that he admitted that he lied, that he did not have any of this money. He had actually run for Congress before in the 9th district, and he wasn't even of eligible age to serve in Congress. So this sort of hijinks have gone on before. But he actually, I believe, told Ms. Young, I was mad at the local party, so I wanted to generate some buzz, and so that's why I did this. So he ultimately didn't qualify and withdrew from the race after all of this came out. And his filing schedule changed then. So his filing schedule actually went to a failure to qualify schedule where he would have just had to, he doesn't have an election year filing schedule. So he would have had another report to file after disclosing this money because he has to close out the account and get it down to zero. And he's never done that. He's never actually closed out his account, never actually disclosed if anyone donated to his campaign, what they donated or anything like that. But we actually saw somebody do this exact same thing in 2022 in the Secretary of State's race, where there was a candidate who disclosed a large amount of small dollar donations and pulled this sort of same exact stunt, got called on it by the news media, and then he said, I lied, and we now have a case on him that's making its way to OSA. But this is, I don't know if this is becoming more and more common, but it's just sort of a weird thing in elections that are happening. People are trying to generate buzz in odd ways, but they're lying on what are official forms. So since he missed 2 disclosure reports, he received the maximum fine of $11,000 from OSA. So that's another one where we're pleased with the outcome there. It's tough to say because when people disclose that amount of money on a disclosure report, people who might get in the race are looking at these and making their decisions based on, how much, if you have a well-funded opponent, maybe I want to sit this one out. So that's why it's really important that these forms are correct, because that could deter someone from running from office because they think it's such an uphill battle. That's why the importance of these forms being true and accurate, correct, disclosing how much you actually have, who's supporting you, is important. So we think, the maximum penalty here was more than appropriate.
I have a question, Mr. Chairman.
On behalf of the bench over there.
Yeah.
So if the campaign contribution was a fraud, he's paying this fine personally then because he has no campaign funds?
Correct. Yes, this would be out of personal funds because I don't think the campaign had any money. So.
And so my question is, if he had worked with you and consented, what would have been his fine? On both cases. I mean, you don't have to tell me both cases, but in this case, what would have been his fine?
It's tough to say because it's such an egregious thing, but also if you're going to work with us and turn over your documents, but then you're going to admit you're lying, I think maybe this is actually the appropriate sanction from us.
Okay.
And it may be a percentage because he's disclosing $100,000, and if you're going to get off on a $1,000, $2,000 fine, everyone's going to do this. So I think the penalty for these things has to be very high, just because of the implications of possibly deterring other candidates from getting in and just generally misleading the public. So I think this is on the egregiousness scale, I think this is pretty far in the egregious category.
A question on both of these are basically, they're both default judgments in
Essentially.
the first one, the defendant didn't appear.
Correct.
And the second one, they sort of tried to appear, but I think we're relying, just for the record, you still have to present your case to the ALJ and make the case.
Yes, and
And then the ALJ has to determine.
by a preponderance of evidence that we've
Right.
met that evidentiary
And
standard.
it's the judge's decision on the they were there, we weren't. It's a little troubling that this person tried to come in and the Zoom didn't work, and I understand all that. But that was a call the judge made in the hearing, and then you still have to present your case.
Correct.
Okay.
Yes. And just to talk about him it was about an hour before the meeting or 45 minutes before the meeting where he decided to join. And then the IT people at OSA were trying to help him, and they were a little dubious of his claims of
And
not being
could have
able to-
come, He was notified and.
Oh, yes, he
These
received.
are in person and this is, okay.
Yes, yes, he received
I'm-
notice.
I spent 11 long years on the Real Estate Commission, and we dealt with OSHA hearings all the time. So I'm much more comfortable with this process but we also met monthly, so the 3-month issue is a real issue, I get that.
Yes.
But we used to get these all the time, and we'd either take them back or take no action or let the 30 days run. And I think on these two, letting the 30 days run is right, because both defendants could raise their hands before this is over.
Correct.
Well, I guess, I'm just going to tell you that I still think there's a flaw in the process, considering we only meet quarterly.
I agree with that.
Yeah.
Because something comes in tomorrow
You won't have the time
that
to
we all
extend it.
Yeah.
would hate
Correct,
unless,
unless we call a special meeting.
yeah.
Yeah.
The flaw is though, because we farmed it out. We farmed out part of our responsibility. Otherwise, a 30-day wouldn't be an issue.
I mean, I don't disagree with that now that I've
Yeah.
heard how that.
But I
how
think
that
that's
process works.
solvable with directions to the executive secretary and our attorney general to, tell us.
But I don't think I can just contact him and say, okay, tell the AG to do this.
Well, at least to notify us.
Yeah.
And it might be useful to adopt a policy on this, just so that we're getting these out within.
Whose idea was it to farm this out to OSA?
What the executive secretary's ever.
No, the real, but in all seriousness, to the chairman's point, the real danger is this, gentlemen. With the process that exists where we can extend it 30 days and 30 days, the real danger is just in the month,
Right.
the 1 month after a commission meeting. That's the only month where an OSA decision can come down, and we don't have the ability to extend it out long enough to get it to y'all, to hear it and direct us to file a motion to amend.
Perhaps that's why y'all always met every month, right?
Well, we had a much more robust docket. I mean, we had 5 or 6 of these a month to deal with.
Okay.
We had
Well,
we had
again-
lots of felons that wanted real estate licenses.
Right, okay.
I'll never buy a house again, but that's another story.
Well, again, I just, want to say that I really think there's a flaw in this process, but I'm going to open the floor. Is there any motion to be made with respect to either of these cases, 2018-0100 or 20-0007C? Any motion? Hearing none, we'll move on to the next item on the agenda. I believe we have an advisory opinion. Mr. Cusack, you're handling that one too?
Yes. And Commissioners, this is an advisory opinion 2023-03. It is from the Defending Digital Campaigns Incorporated by and through their counsel, Wiley Ryan LLP. By way of a little background, I'll term it the DDC. That's what this organization is. They, in federal elections, they have received an advisory opinion from the FEC in the 2020 and 2022 elections. They were able to give campaigns cybersecurity resources to help them just protect themselves from foreign hacks or any sort of cybersecurity leaks, anything like that. It's sort of an interesting line of, I guess, election work now, in that these leaks or hacks are becoming more and more prevalent, just because of all the sensitive nature of the communications that may be in a campaign, and the potential to embarrass or influence candidates. So what the DDC has done is basically aggregated a bunch of useful resources for campaigns to utilize cybersecurity items. So what they have asked is it okay for them to give campaigns these cybersecurity things that they have in their arsenal? Some of these may be at no cost, some of these may be at a reduced cost to them that they're providing through whatever providers that they are working with. So just for example, they have like a multi-factor authentication system that they can give campaigns. They get it from the vendor who built this, and then they're able to give it to the campaigns at whatever cost that they please. So they want to make sure that they are not making an in-kind contributions to campaigns because they have this sort of discount or they're able to provide these for free. And so the analysis here that we undertook, we said, yes, you can do this, that you are able to provide these resources at a free or reduced cost, and you aren't making an in-kind contribution. And I've sort of, I said yes in two ways on this question that was presented. I used sort of the analysis of just because you go to a place where you're able to get a deal like Costco or something like that. Costco isn't making an in-kind contribution to your campaign because the prices at Publix were more. You're just a good shopper. You're trying to get your campaign the best deal with the resources you have. So we're saying that, no, this isn't an in-kind contribution. You're serving as a marketplace for these resources. But we also said that this doesn't meet the definition of a contribution to a campaign. It's not intended to influence an election. And that was more in the line of what DDC thought what our analysis should be, is that these aren't intended to influence an election. They're done on a nonpartisan basis. Anybody has access to them if they meet a de minimis amount of funding for their campaign. So everybody has access to this. I think it's anybody that's in a general has access to these resources. So anybody that makes it to the general election, and I believe on the primary election, it was something like $2,000, which most campaigns are going to have. The FEC has already said the DDC is okay to make these types of resources available. So they're in federal campaigns right now, and now they're going through the states to make sure they're in compliance with everybody's Campaign Finance Act. And we've said yes, you are. I will say, I think the state portion of this, they're going to other states this year because they're going to be present for the 2024 elections in other states. So that's why they're seeking this analysis now, because they've had such success with this program on the federal level.
Any questions from the commission or comments from the commission on this?
I have one.
Sure.
I take it they don't create product. They scan the marketplace for products that other companies vet them and then create packages that they present to candidates saying, we've looked at all the different products out there.
Here's the best.
We think these are ones that work well for campaigns. So the campaign doesn't have to do all that. And then they say, if we get it free, you get it free. If we have to pay for it, you pay us back. But they're creating just packages and saving the campaign from having to call up all these vendors and, okay.
Correct. And so say there is, and I just wanted to make this point too, if a campaign does have to expend money for this, campaigns would still report it as an expenditure. So it's still a campaign-related expense for them. But that doesn't affect the DDC if whether or not the campaign pays for something has to disclose it on a disclosure report.
But if they get it for free, they don't have to show it as an in-kind.
Correct.
I agree with this decision. I would kind of want it to say that they have to provide it to everyone. The bottom analysis is that it's not a contribution. And one of the reasons it's not a contribution, especially if they give it to everybody, right? So, I agree with the decision, but that's the only point I'd make.
This doesn't
Say all.
This doesn't say that?
The requirements in the primaries is that you have to have total receipts of, I think, $2,000, which I rarely see campaigns that are under $2,000 in state elections. So it's sort of almost like a de minimis requirement here. And that's, anybody in the general gets it, so.
I always find, the executive secretary will support me on this, that I always find a couple things. Y'all have my name spelled wrong?
Nice. That's the way.
Yeah.
That's the way to go.
I'll have to own up to that one. Yeah.
And I'm not going to, I'm not going to propose an amendment on this, but, the the second sentence on the first page, I'm just not sure that makes sense. I mean, I think you could say it, DDC is no different than Target or Home Depot in this analysis, period. They are the marketplace or provider of products and services, comma. And just because they offer every campaign or political party a discount, this discount does not magically turn every transaction into a in-kind contribution. I just-
Middle.
Yep.
Yeah.
Yeah. Again, all it is just fixing that sentence. It's a very, very long sentence. I just don't want there to be any confusion about what it
Right.
says. But anyway, we don't necessarily need an amendment to that if it makes sense to all the other commissioners. So I guess, again, the only amendment that I would propose would be to my name.
Yes, I'll get that fixed.
Do we have any other questions or comments with respect to the advisory opinion? I did forget to ask, Mr. Cusack, did you receive any written comments with respect to the advisory opinion?
I did not.
Is anyone present today to make any oral comments upon the advisory opinion? Erwin, you may want to check that. I don't know if Mr. Chalmers is still with us.
Yeah, he's still here, but no one's raising a hand or anything, or even saying anything on the chat. So.
Okay, all right. Well, does anybody have a motion?
I move to approve the advisory opinion with your name corrected.
I'll second motion.
I got a motion and a second. Any discussion? All in favor say aye.
Well, a little discussion. Just a thought, gentlemen. What about we approve it with the name incorrectly spelled?
Yeah, okay.
I think we should move to change his name. It'd be easier.
All right, we got a motion to discuss, and a second. Any discussion? All right, hearing none, I'll go ahead and call the question. All in favor say aye.
Aye.
Any opposed? All right, that advisory opinion is approved. Now we have a proposed rule.
Yes. Commissioners, we are proposing to add a new chapter to our rules, but also this specific rule. It's going to be Chapter 189-8, and it's going to be titled Leadership Committees. And then Rule 189-8-.01, it's going to be on what a political party is for terms, or for the statute. I'll read the rule real quick and go into sort of the analysis and why we're requesting this rule be enacted. But 189-8-.01, political party, it's going to read, for purposes of OCGA 21-534.2A, political party shall include any political body which is duly registered as provided in OCGA 21-2-110 and qualified to nominate candidates for statewide public office by convention pursuant to OCGA 21-2-18. And let me just go back to one of the previous advisory opinions this year, which was for the Libertarian Party. In that AO, we adopted the opinion that the broad definition in the Campaign Finance Act included the broad definition of political party included the Libertarian Party, and that they were able to run multi-candidate ads as a registered political party, because the Secretary of State's definition and our definition of political party was much more broad than what the Secretary of State's definition was. So they are able to run multi-candidate ads and make contributions and expenditures to the party ticket that they have in an unlimited amount. This rule is an extension of that advisory opinion and makes clear that the definition for political party includes the parties that nominate their candidates by convention. So as of right now, we have the Libertarian Party, and I actually got a call from the Green Party the other day asking for some guidance, and they were saying they nominate their candidates by convention as well. The reason we're enacting this is, as you've received updates, there is a lawsuit in the 11th Circuit right now on the leadership committees, and it's the Libertarian Party saying that since they are unable to form a leadership committee, that they have been, I guess, prejudiced by that. And so what this rule is making clear is that the Libertarian parties can have a leadership committee, that the definition for political party in our code, in the Campaign Finance Act, is more broad, and we believe this will ultimately help with that lawsuit and moot that issue. And so the Libertarians would be entitled to have a leadership committee for their people who are entitled to have one, which would be their nominee for governor and lieutenant governor.
Mr. Cusack, I actually did diagram these three statutes out that lead to the rule. And again, I've already discussed this, but I just want to make sure that you agree with it, that, what we're looking at is 21.534.2, right?
Correct.
All right. And there are only two references to political parties in that statute, and they both fall under subsection A.
Of that statute?
Yes. I mean, that's the only place
Correct,
that
yes.
this rule is going to apply, is just going to be to
Yes.
subparagraph A in that statute.
Yes.
Okay.
And what does that say?
It's who
I'll
is,
give it to him to look at.
yeah.
Okay.
I was just curious how far.
Because the
reaching-
leadership committee is formed by the candidate, not the party. That's what I was a little,
It's formed by the nominee of the party.
the nominee of the
Yes.
party.
Right.
And so we're clarifying which nominees
Are entitled
are
to.
allowed to
To do that.
form
That's
leadership
right.
committees.
Yes.
That's right.
So any nominee of a party that has a convention
Would
can
be
have a
entitled.
leadership committee
Yes.
for these limited offices.
For those two offices.
Two
Right.
offices, yes.
Okay.
I don't believe it would apply to the General Assembly because there's only
Right.
two parties represented there, so.
Okay. Any other questions or comments with regard to the proposed rule? Hearing none, I'll go ahead and make a motion. Make a motion to approve the Rule 189-8-.01 as to leadership committees as presented. Do I have a second?
Second?
Got a motion and a second. Any discussion? Hearing none, I'll call the question. All in favor, say aye. Aye. Any opposed? All right, that one also carries. I know we're going to push on through, but we're going to take a little short break, maybe 10 minutes.
Okay.
And then we'll come back in and finish as opposed to taking any break for lunch. Is that okay with everyone? All right. We'll be in adjournment for the moment. I'll call the meeting back to order. It looks like we're on number 9 in the agenda. So, sorry. There's too much technology. There's too much technology.
I did. I did him. Yeah, I did him.
You indoctrinated Bryce.
Not really. It was 2 questions. Hopefully we'll have more cases on the next meeting where we can really,
That's right.
punch the ticket.
Yeah, I was about to say, I got a ton of questions my first couple cases.
One time I
Got
did
off pretty
that,
easy.
and a certain individual actually got mad. Start
We're
calling
good?
names.
All right. I'm going to go ahead and call the meeting back to order. Again, Mr. Cusack, I think we're on number 9. I think we're on number 9. And
Recording in progress.
it's proposed legislation. Go ahead and give us an update on that.
Yes, commissioners, and this can be sort of a free-flowing conversation as well.
Well, does the proposed legislation have anything to do with our, rejection of
No,
an
no.
opinion
Yeah, there's
within
no vote.
30
This
days?
is a legislative package we're going to put forth this year, and obviously, we're open to any input or any ideas you guys may have as well. But these are some of the things we've identified to try to streamline and make the Campaign Finance Act a little easier. But the first one I'll start with, and I think this ties into our lobbyist system as well, but I've talked about the lobbyist system and those reports, and they currently have 5 reports that they have to file at 5 different levels. It's a state, when you're lobbying the General Assembly, state agency, a vendor, local, and then the State Transportation Board. Now, all of these reports disclose the same thing, who you're lobbying, what you're lobbying on behalf of, if you make expenditures. It's the same report, but it's 5 different reports that have to be filed at 5 different times, depending on whether the General Assembly is in session, they're out of session. It's sometimes twice a month, it's sometimes once a month, sometimes it's on the 5th day, sometimes it's on the 1st day. So what we are proposing is that we just take the lobbying reports and we make it one report due at the beginning of the month. These reports would be essentially condensed into one, and say you're lobbying vendor, State Transportation Board, state, all 5 levels. It will just all be disclosed on the same report, and it's due at the same time every year. And this is going to create, we get a lot of people who have late fees because they're like, I didn't know the General Assembly was out of session, or, I was a little confused on the dates. So now it's just going to be same time every year, one report due, as opposed to 5 reports. I asked a ton of lobbyists that have been around the General Assembly for many, many years. I said, can you tell me why there are 5 different reports? And nobody had a good answer. So this is something we're putting forth. We think this is going to make this more digestible and easier for the lobbyists to use, but also easier for the public to be able to look at these reports. They're all in a central location, and you can see who that lobbyist is lobbying. So that's the first part of this. The second part is the reporting dates for the candidates as well. So we would rather, at this time, the General Assembly files in June and January in non-election years, and judges, Public Service Commission will file in June and December of non-election years. The election year filing is all the same, and it's 6 times a year. What we're proposing is everybody files at the same time 4 times a year, no matter if you are the governor, no matter if you are the coroner, no matter if you are in the General Assembly, if you're a district attorney or a judge, 4 times a year at the same time every year. So what that's going to do is just standardize our filing system, standardize all the candidates in that everybody files at the same time every year. It's going to make our lives easier for putting in filing schedules for all the candidates. You could just pick a 2 or 4 year cycle depending on if you're in the General Assembly or not. But it's going to definitely change all of this. Well, I'm subsection A, so I file, I think, in June and December, or maybe I file in January and June. We're gonna get rid of that, and we're just gonna standardize it to where you are filing 4 times a year.
And correct me if I'm wrong, Mr. Cusack, but this proposal would come in line with with what the federal campaigns have to do as well.
And it's based off of the FEC, because
Yep.
it makes a lot more sense where you're just filing at the same times every year.
And it would be irrelevant whether it's an election year or not an election year, it'd just be,
It'd be irrelevant.
so we wouldn't have the 2 weeks before the vote and
Right, it would just be.
isn't there like a 2 week after the vote?
No, there is.
It's just quarterly period.
Yeah, it's just quarterly period.
So like if the election day is November, you would see what, on December 31st, you would get all those last minute.
Yes, it would be on that report.
Would this, and this is actually genuinely a question, are you suggesting we do away with the 2-day reports in that interim? Or are you saying within the interim before the election, if there are the over $1,000 the big donations in the blackout period, that they still get disclosed?
Now, I really, at this point, I think we should do away with the 2-day business reports. They have become, just from the feedback we've gotten from our candidates, and especially with the contribution limits rising, a $1,000 contribution, disclosing it is not what it used to be. The 2-day business reports have caused so much confusion for people. They think they're due at all times. So I really think getting rid of those is going to make everyone's life easier. It doesn't make a whole lot of sense anymore going forward for those 2-day business
Curious your
reports.
thought.
I understand.
For that too. Yeah.
I understand why they had the 2 business, and I also understand why they have like a pre-election report. I don't think the 2 business day report does anything for anybody because we have the contribution limits. Nobody's looking at them, I can't imagine.
Right.
The press doesn't report about them, or anything like that. I don't see, I'm with him, I don't see a purpose. I do, however, think maybe some of the pushback from the General Assembly is gonna be if we don't have a pre-election report, which, and that's how we have the goofy ones now.
The October 25th.
Yeah, the October
Yeah.
25th, and you did change it to April for the May election, that's why they changed that. I think there'll be some pushback on there, but again, I don't think it changes anything. I like the quarterly report, you know. Of course, I like it confusing too, for different reasons.
But also on that same note for candidates as well, we're talking about changing the filing schedule for when you leave office and when you're an unsuccessful candidate. So right now, if you leave office and you were elected and you served in public office, you file on June 30th and December 31st each year until those contributions.
Like a retiring.
Yeah, a retiring legislator or somebody who is term limited and has left office. They file on June 30th and December 31st each year until those excess contributions have been expended. It's a supplemental reporting. But say you lost that a race, and you would then have to file one report by December 31st of that year. It's just one report. It makes no sense of why it's different. And so what we're proposing too is that everybody would still file quarterly until that money is expended. You would still file those quarterly reports.
As opposed to you and I run for the same office. I win, you lose, then I retire. We have different schedules even though we ran for the same seat.
Correct.
I think that pushes people to terminate their committees too.
Which
If they know
is-
they have to do it 4 times a year.
Which is a good thing.
Yeah, which is a good thing.
And to be honest, then we wouldn't be dealing with, the Oxendine case like that. That would have had to file more, and, the spotlight falls off people when they leave office, and I think that's when there is actually, the money is ripe for abuse. Because then you can only dispose of those funds in 5 ways, but when the spotlight's off of you, I think that's when these funds are sitting there, and you can, we've seen people get in trouble for using those in ways they shouldn't be. So that's part of the date change we're proposing as well. I'll talk about the personal financial disclosure statement. We've had some interest from the General Assembly, and this sort of comes in on the advisory opinion the commission adopted a couple years back on security systems. It's an ordinary and necessary expense now if candidates are incurring security costs from the nature of their office, that they could use campaign funds for security systems. So we're proposing that the home addresses, we've started advising candidates that if you don't want to disclose your home address, disclose a PO box, disclose a parcel number. Judges and district attorneys have been especially reticent to put their home addresses out there. So we're proposing that we start redacting those home addresses, that contact information, or we are required to remove it. This could be part of a broader bill at the General Assembly this year on any public documents for public officials, but it's something that we're aware of, and it's a different political climate with these addresses being out there than it used to be.
I'll just tell you gentlemen, that I'm pretty tied in over the legislature, what they're looking at, what they're not. This is something that's going to happen independent of us. I actually thought it would happen last year. But with the proliferation of social media and threats that have been out there, this is something that, we took up an advisory opinion, 2 years ago, not even, kind of dealing with home security and because of these threats. So I think this is something the General Assembly is just going to do.
And on the personal financial disclosure statement as well, we want to standardize the dates that they're due. As of right now in election years, the statewide officer has to file 7 days from when they qualify their PFDS, even though a lot of these are very comprehensive and intense documents that take a long time to fill out. The General Assembly and district attorneys, every other office, they have 15 days from the date of qualifying to file that personal financial disclosure statement when they qualify to run. Every other year, they have to file by July 1st, so they have a 6-month period. What we're proposing is just the same day every year, and that we're looking at either a March 1st or an April 1st type date, so that every year it's the same day. It's none of this, well, I have to do it 15 days, but I'm running for Attorney General, so I have to do it 7 days. It's just going to be on the same date every year the personal financial disclosure statement is due, so that, when we're giving guidance, same date every day. So we're looking at that, of trying to standardize that date. And
what day are you looking at?
like probably March 1st or April 1st, March 15th, somewhere like that, where we can, it's far enough into the year where they can get a proper look back on their finances from the previous year, but far enough into the year where, the public will be paying attention, and also it's before elections. And
I think the ideal date is probably looking at April 1st, because that's after qualifying's occurred, so we know, who's in, particularly during election years. But
And the voters can, see if there's any conflicts or anything. That's
it's
what
still
that
enough
document's
time
for.
before the actual election that people can review those documents.
The next one we're proposing centers on complaints. Right now, there's a commission rule that says we cannot accept a complaint within 30 days of an election. It sits in a holding pattern, and then after the election, we make a decision whether to accept or reject that complaint. We want to put that into statute, but make it 60 days, that within 60 days of an election, it sits in a holding pattern. And what we have seen happen is campaigns try to use us as a weapon against their opponent. And a lot of times, and this happens often, is we will get a request from a news agency for comment on a complaint we haven't even received yet, because it's in the mail, because the campaign has leaked it to the news, and they want us to comment on it. So what this does is that when it's in that election window, in that 60 days, it sits in a holding pattern. Commission rules could come and go as the commission, but this puts it into statute and formalizes that. And so we become less of a political weapon that people try to use. And then we can take up any decision we make after the election, after the voters have spoken. So we want to formalize that and put that into statute.
So they can still file, they just get held?
It just gets held. We don't make it, right now, within the 30-day window, they get a letter that says, the commission has not made a decision whether to accept or reject this. It is going to be, you will receive a decision after the election.
Okay.
So that's how we do it right now. But campaigns have gotten creative, and on 31 days before the election, they'll do this, and then leak it to the media and try to make a issue out of it, even though it's a minor complaint or something like that. The next one centers on political action committees. PACs in our state, they have to start filing after they cross the $25,000 threshold for that year when they've given to candidates, or their total expenditures are over $25,000. What that has led to is a lot of weird filing schedules that have popped up for the PACs. So sometimes you will have a PAC that has, a lot of money, and they make expenditures or contributions for 1 year. They won't do it the next year, and so there's no registration, and then they'll come back maybe 2 years later, cross that threshold, and it throws off all the filing schedules. It throws off the amount of money that's in there. There's really no transparency on what the money's being used for in those years where the $25,000 isn't crossed. So what we're going to ask the General Assembly is that once PACs are registered in our state, they're required to open and maintain a separate bank account until they're terminated. And then they are required to file quarterly reports with in election and non-election years until that bank account is zero. It's sort of like the same thing with the candidates. And they'll be required to file until they want to terminate as well. They could terminate. So right now, their schedule is based on when the candidates they support file. So it's sort of a loose, sort of a squishy type of schedule. This is going to actually say, all right, you are filing quarterly every year until you terminate the campaign. So there's transparency on the money the whole time that the PAC is active. So that's something that it's made the reporting schedules for them, and it's made our reports and having to fix the reports sort of a nightmare. But it really doesn't make sense why there's no light shown on this money on what they're doing.
Are you suggesting that they have to open a bank account in the state so that you have subpoena power over it, or no? Because you said open a bank account. So
Open it, yes.
Or does it matter?
No, we know we have campaigns that have out-of-state out-of-state, I guess, accounts, but that could be an added thing
I know
to,
half the states do it, half the states don't.
Yeah, I hadn't even
Yeah.
I mean,
contemplated
it's
that.
kind
Yeah.
of about both,
yeah.
but you'll get a lot of pushback on that probably.
You could probably get it, with a commission from the other state.
It's hard.
Is it?
Yeah, it's somewhat difficult if the bank doesn't, no, from national banks, we've never really had a problem, but.
Does it have a branch?
Yeah, as long as they have a branch in Georgia, but like, for the most part, they'll respond to our subpoenas, but I hope it
Yeah,
doesn't.
Again, what I was talking about was to get a subpoena issued in the other state, you send a commission to the clerk over there, then they can go ahead and run the subpoena out of state.
Yeah. And then the final one that we're proposing, as of right now, individuals in our state are treated as PACs. It's somewhat strange in that individuals are required to register with the commission and disclose their contribution to candidates when they have made over $25,000 in contributions in that year to candidates. We're proposing that we get rid of this. This is already on disclosure reports for candidates that these individuals have donated to their campaign. It's an added burden on these individuals and could really infringe on their First Amendment rights. But we're proposing that this go away, and this information's already disclosed. It's a redundant disclosure that these individuals have to register and then disclose stuff that's already been disclosed before. So.
You buried the lead. Talk about locals.
Oh, yes, that too. That's the big one. Yes, we're proposing that local candidates start filing back with the commission as opposed to with their local election boards. And the reason for that, we have however many counties and municipalities, it's a ton.
159, 536.
Yeah, a ton. A lot of candidates, local candidates come to us and say, my elections clerk told me I didn't have to file this. I didn't have to file these reports because it was a non-election year. We've had election clerks say they don't have to file in non-election years or that they have to file at the wrong times. They're getting advice from all over the place. It's gotten to a point where we're getting emails every week having to correct stuff from the local election clerks. And this isn't a big part of their job either. It's uploading these. They have many other duties. And the advice that's been given and what we're having to correct it's taken up a long time of our education staff's resources and time. And so if it's an automated system and it's just 4 times a year, there's no question of when they have to file. Our filing schedules will be easier because you're picking either you're a 2-year office or a 4-year office, and then you're getting notifications from us of when you have to file and when those filings are due. So there's no question of what your requirements and responsibilities are anymore.
When did that change to go back to the locals?
2014.
Yes.
Does anyone know why that change was made?
I know.
ACG and GMA pushed.
Because they wanted it out of the state, because when we first tried to pass the law to get it brought to us, they fought us really hard, GMA and ACCG. And then they got it pushed back because they want to protect their elected officials because that's who they work for, and they don't care about the clerks.
Yeah, I mean, it's a little bit of a conflict that it's at the local level
Sure,
anyways,
yeah.
because these clerks who are supposed to transmit these reports to us, whether they're late or something, is in there that's problematic, work for the people that, you see the inherent conflict. Additionally, and everything Mr. Cusack said is right, the other problem we have is we'll have counties or cities that don't regularly transmit it. We have to hassle them to get it.
Yeah.
Or, as we saw maybe a commission meeting ago, we had a county that we found out had been retaining the fine, the late fees, themselves as opposed to transmitting to the state. So there's just a lot of problems that matriculate when it's local. Now, paired with this, candidly, if it's coming back to us, we would be asking for additional resources because we would be effectively replacing 159 county clerks and 5, the volume of questions coming in would be greater, but I don't think that increase in resources would be very significant.
Because you no longer take paper registration anyway.
Right.
You make everybody do it electronically, so that keeps a lot of it off. And they should be calling you with questions anyway.
Sure.
Yes.
So
But that's what we're proposing right now.
for transparency, if if anyone's listening, that may have texted me that I'm not about transparency.
But that's what we're bringing in the form of a legislative package this year.
Any questions or comments for Mr. Cusack about legislation? The proposed legislation? All right, I guess now we'll move to Mr. Amati for the report of Executive Director, item number 10.
Yeah, so I have three things I want to talk about. The first is the lobbyist, the new lobbyist e-filing system and the registration process. And I was assured by Mr. Cusack that Commissioner Thompson just had rave reviews of this after being skeptical in September, that he would concede that the feedback thus far has been overwhelmingly positive.
Let's not get crazy about how great it is, but it is better than.
It is better.
It is better than what I thought.
So we spoke at GPLA a few weeks ago, Mr. Cusack, Ms. Barrett, and I, and gave about 75 or so lobbyists that were present a demonstration on how to register, what that process looks like. The system went live right around Thanksgiving, so a few weeks ago, which is the earliest we've ever opened it. Typically, we don't open it until right about now. And I can tell you, we've already got 130 or so lobbyists registered, which is over 10% of our annual. So in a new e-filing system, we've got over 10% of the lobbyists already registered at a time where it's usually not even open. And that's, to Commissioner Thompson's point, better than I could have hoped for. And the feedback we've gotten is really good. We've got another 20 or so clients pending approval today. The feedback's been great. And Commissioner Thompson thinks it's just been phenomenal. So I can't say enough good things about the process so far with the lobbyist system. Training updates, this has been a big effort, as you all know, this year. It's part of why we're sort of taking these commission meetings on the road much more. Can't remember if we had told you about the July 11th local filing officer training we did with the Secretary of State for qualifying officers, but that hosted around 300 or so local filing officers throughout the state that we participated in a training with the state's office. And we had one in Jefferson I did talk to you all about. So the day after our Athens Commission meeting, we had a local filing officer training up in Athens. We spoke to the clerks conference, and there were 200 or so city clerks, or that was actually right before the commission, excuse me. Spoke to 200 city clerks from around the state up in Athens in September. And then September, 4 days later, the day after our meeting, we had another training with local candidates for office in Athens at their extension office. And that was, I think, 40 or so local candidates attended. So that was very good. In October, we spoke at COAG, which is the Constitutional Officers Association of Georgia. Spoke to, that was more so probate judges, superior court clerks, tax commissioners, and sheriffs that attended. Had a good turnout. COAG's they put on a big thing. And then a few days later, Mr. Cusack went up to Brasstown and spoke to the Solicitor Generals and the DAs at their conference. Talked about the life cycle of a campaign, kind of some unique things that they could use their campaign funds for. Obviously, they were very interested in the security advisory opinion that we passed. I think a lot of them didn't know about that. And then yesterday, we hosted a training here in Savannah with both local candidates and local filing clerks, and had a solid attendance there. Next week, we're speaking at Gavro, and we know so far we already have the Georgia Clerks Conference scheduled for June of next year, and GMA for June of next year as well, but we're now working on building out the 2024 training schedule. So good results. We've been all over. I think we're definitely getting out there as well as we've done in the 5 years I've been here. Lastly, we were reached out to by the State Department on behalf of the International Anti-Corruption Champions Initiative. And the State Department reached out on their behalf in regards to setting up an informational training that we could conduct about what we do here in Georgia and various investigative techniques and practices we have that representatives from the Liberia Financial Intelligence Bureau and the Special Prosecutor's Office in Montenegro could glean. And so when they reached out, they said they were reaching out to, ethics commissions and other agencies of that type across the country, sort of dispatching different members to different, and so we said, sure. And so they'll be attending along with some, I guess, Serbian, Croatian representatives and translators as well. And Mr. Cusack, do we have a date for that yet? 14th, okay, so I thought it was soon. So that'll be next week, which, it's not something we run across every day, so I thought that was interesting. But with that, Mr. Chairman, that's all I have.
Okay. Any questions for the executive director? All right, we're going to go ahead and move to Ms. Young for item number 11. We'll get the report from the Attorney General's office.
Okay. Hey there. Just a couple of quick updates for y'all on all things appellate and litigation oriented. We will be having a hearing in the 11th Circuit on Wednesday in the Libertarian Party's Leadership Committee case that was discussed earlier. We also, sometime in March, the week of March 25th, the actual date has not been published yet. The 11th Circuit will hear the New Georgia Project case that involves the challenges to independent committee and ballot committee statutes. Also, with regard to New Georgia Project, the case involving the subpoenas that has been in litigation for many years now, we recently received a follow-up order from Judge Barwick to the Court of Appeals order that had ordered New Georgia, had ruled that it had been error for Judge Barwick not to grant our motion to compel production under the subpoena. New Georgia Project took the position that that Court of Appeals order, which was made the order of the Fulton Superior Court administratively without a specific remand order, that was not sufficiently directive for them to have to actually produce anything. So we were able to get a follow-up order from Judge Barwick that says, yes, that was a directive from both the Court of Appeals and the Superior Court, and they were ordered to produce the documents to us in Stanter. But in any event, if we have not received those documents by January 3rd at 5 p.m., that New Georgia Project should expect that hearing will be set to for them to show cause as to why they should not be found in contempt. So that date is on our calendar.
In front of Barwick?
Yes.
You mean the Abrams campaign, not New Georgia?
Yeah, I apologize. New Georgia Project was a party to that
Right,
case.
right. And I know we've got the separate
Yes,
New Georgia.
I apologize. Yes, the subpoena, although New Georgia Project was a party to that case, the specific subpoena that's being enforced is for the Abrams for Georgia campaign. So thanks for that correction. And we've already discussed our OSA cases that have happened since then, so I'll leave it at that.
Any questions or comments for Ms. Young? All right, we're going to go ahead and move on to item number 12, the confirmation of dates.
So,
Is that going to depend on, where we're moving around the state?
no, I've got the locations proposed, and
Okay.
I've got date options for y'all to look at your calendars. So the only one that's a little more rigid is March, just because we're in Atlanta, we need to be in Atlanta because session, and we're dealing with the CLOB and General Assembly. So we're proposing either March 18th or March 25th.
What day of the week is that?
Monday, I believe. Let me double check, but yeah. And just for anyone who's not aware, the reason I do those on Mondays is because it's the one day I know Sine Die won't be the day before. So I'm not worried about being at the Capitol till 12 and being back up here at, 7, 8 in the morning setting up. That's just for me. But March 18th or March 25th, if one works significantly better than the other.
18th works better for me if that's.
That's fine.
Okay. Mr. Birch,
Either are fine right now.
Stan? All right, so we'll go with March 18th at the LOB. moving to June, and we're going to do sort of the same model for June, September, December as we've done the last two meetings. I'm going to give you 2 weeks, and I'm going to give you 2 days in each week because we're going to do a training tagged along where we're at. But for June, we're looking at Blue Ridge up in North Georgia, and we could do June 17th and the 18th, or 20th and the 21st. And actually, that's.
Are we having the training before or
We-
after,
we
or
can
it
do-
doesn't matter?
The training will be dictated on what day works better for the meeting.
I'm good with any of those.
What were the dates again?
We could do it Monday or Tuesday, the 17th or 18th, or we could do it Thursday or Friday, the 20th or 21st. And, Miss Easterwood's sick, but I believe we specifically set that one all on the same week to avoid getting closer to the 4th of July.
Well, that disclosure report's the end of
Yeah.
the month.
Yeah. So,
17th works for me.
17th?
All fine, yeah.
Yeah, that's fine.
June 17?
All that good? So
Yeah.
we'll do the 17th for the commission meeting, and we'll do a training on the 18th.
Where's that one going to be?
Blue Ridge.
Oh, sorry.
Yeah. So September, Macon. And we're looking at either the 12th, hold up, the 12th and the 13th, which are the Thursday and Friday, or the 19th and the 20th, which are the next Thursday and Friday. So I don't know if one day or one week works better for y'all.
Conference out of town, the 19th and 20th.
Okay,
That's not a good time for me either.
okay. Does the 12th and 13th work for you three?
Yeah, and let's do ours on the second day.
Okay, so we'll do the
Is that okay
commission,
with everybody?
13?
Yeah.
yeah, we'll do the commission meeting on the 13th, training on the 12th, and that's gonna be in Macon. And, the mayor pro tem down there is a friend of mine, so I think we can get a setup kind of like this for certain. I don't know about Blue Ridge, but I feel good about the location for that, at least. And then, December, we're going past the Nat line, gonna go down to Valdosta. And, correct me if I'm wrong, we prefer the 5th and the 6th of December, because that doesn't interrupt with the Kogel, the annual ethics conference that we go to. But we could do the week after.
What is Coco?
Through the 11th.
I prefer the week after.
Okay,
I do too, because I usually have something that first week,
okay. Well, then, we can do that.
another meeting, so.
I'd prefer, if we're gonna do that, I'd prefer to do the meeting on the 14th to give us a little more time to get back from the conference and
That's a Saturday.
the. Okay, I meant the 12th and 13th, so, does the 13th work for people?
Works for me.
Yeah, that's fine. Let's do ours. It's what now? That's not okay.
She's celebrating with us.
You had a hotel in Valdosta. That's a great celebration.
Can we do ours on the 13th?
Yeah.
On that one? Okay.
So we'll do the training on Thursday, the 12th, and we'll do the commission meeting on Friday, the 13th.
You get back within a couple hours, so.
And that, gentleman,
We're good?
sets the 2024 commission meeting dates.
Okay.
Haley, do you have all that down? Thank you.
Any public comment?
Do we
I
have
don't-
one signed up? Are they present?
On Zoom, Becky Langston, I believe.
I couldn't hear you. Becky who?
Becky Langston.
I still didn't hear her.
Becky Langston.
Langster.
Langston?
Langster.
Langston.
Oh, Langston.
Yeah, Langston.
I'm sorry, I couldn't hear him from back there.
Okay, I have just have her unmuted right now.
Well, we'll go ahead and hear from her.
Can you hear me?
Yes, ma'am.
Okay, thank you. Thank you for allowing me to speak today. By way of introduction, I'm a Harris County resident, and I'm also a retired Harris County Commissioner of 12 years. Is it possible to go back to one of the administratively dismissed cases 5G?
Well, that,
Is it,
again, there isn't any action, for us to take on those matters, but, I mean, unless some
I
other
actually-
commissioner's got a problem, I mean, I'll let her speak on it.
She can speak on anything she wants to in public comment, right?
Yeah. Yes, ma'am, you can go ahead and proceed.
Thank you, I appreciate that. Thank you very much. I actually am looking for some clarification. The original complaint was on the non-filing of PFDs for that commissioner. And I reached out a couple of weeks ago, to Mr. Knittel, who shared with me that this particular commissioner was in compliance with everything for the Ethics Commission requirements. He shared with me that since that commissioner had signed an affidavit not to spend more than $2,500 on his campaign, and he had only spent $750 out of his pocket for signs, that everything was fine. But a complaint not on campaign expenditures. The complaint was on the late filing of the personnel financial disclosure. And I just wondered what was the reason for the administrative dismissal, as Mr. Knittel did not address the PFDs.
There's no,
Well,
he could state the reasons.
it looks from the dismissal to me like the late fee was paid before the complaint was filed.
Move on. There you go.
So the late fee was
That's fair.
paid.
That's fair.
Yeah, I mean, again, there's nothing that requires any type of, response to public comment, and I believe that's what we've always done
Yep.
with respect to these. Ms.
So
Lang?
I cannot receive a response to that. I have also reached out to Mr. Knittel via email and he has not responded.
Well, again, I think that if there's a remaining issue, and, you want to proceed with some type of complaint, and the statute hasn't run or whatnot, then you can, file your third-party complaint. But again, I'll just leave that to the staff, and, I appreciate your comments. Is that it that you have today, or is that all you have today?
That is all that I have today. Thank you very much.
We thank you for attending. Any other public comment? Hearing none, I'll go ahead and move to item 14 for adjournment. Do I have a motion?
Second.
Got a motion and a second. Any discussion? Hearing none, call the question. All in favor say aye.
Aye.
Aye. Any opposed? All right, we'll see everyone at the next meeting.